Hi, everyone. I'm Beth Rebay. I'm the host of the Civics Project and also the director of Repair, which sponsors the Civics Project. Before we start today's episode on higher education, I wanted to share a brief land acknowledgement. Excuse me. Repair acknowledges the Tongva peoples as the traditional land caretakers of Tovangar, the Los Angeles Basin and South Channel Islands, and we are grateful to have the opportunity to work for the Taraha Tone, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Ahihiram, the elders, and Eohinkem, our relatives and relations, past, present, and emerging. So as noted, today's episode 33, focuses on higher education. And I want to begin by just tracing a little bit of the history of higher ed in the United States. The oldest university on this continent is Harvard University, which was founded in 1636. Its original name was New College, but it was rapidly renamed for one of its major benefactors, John Harvard. So his donation to the university, which included half of his estate and also his library, basically occasioned him becoming the namesake of the university as a whole. There were a number of other major universities which emerged during the Revolutionary War period. These included the Columbia University, Yale University, St. John's University, William and Mary College, University of Pennsylvania, Moravian College, University of Delaware, and Washington Lee University. So again, these were all emergent during the colonial period and more emerged rapidly after the Revolutionary War. Colleges in the United States have a history of social protest, which at least as it's been documented, dates back to the 18th century, around the 1760s, just before and at the onset of the Civil War. And the nature of social protests may be about issues in the broader society or may be about changing or challenging the structure of colleges and universities themselves. Both of those show up as early as the 1700s. And I said 1760s, so no, before the Revolutionary War and well before the Civil War, which I was thinking of in the 1860s. Colleges and universities also have a history of conflict about their own purposes. So some see colleges and universities as primarily about theology historically, meaning promoting religion, the formation of character, being prepared to be a good citizen, learning more about society. Others tend to view it primarily as about preparation for the workforce, so skills and vocational training, workforce development. And contemporary universities have some of each of those characteristics. Between 1865, so once we did hit the Civil War aftermath, from 1865 to 1915, we had a 50-year period in which a lot of the conventions of contemporary universities and colleges emerged. And these included letter grading and having departments based on different areas of study. And the idea of electives, being able to take courses not just in a single area, but in various subjects that interested you, even if they weren't going to, for instance, contribute to your employment deliberately. We also started to see colleges and universities develop majors, so things that students could choose to concentrate in, and the counting of credit hours, so the number of credits a person needed to complete in order to achieve a particular degree. So again, while we had universities dating back as early as the early 1600s, the New College, which then became Harvard University, the sort of structure of contemporary university emerged gradually over about the last 150, 160 years. The role of higher education socially encompasses a number of different tasks. So one is that higher education is basically a form of gatekeeping to move up from blue collar to white collar or professional positions. So in other words, higher education is what allows you to open up or expand your economic and professional opportunities. So it serves that social function. Historically and today, higher education also is about the transition to adulthood. While we certainly have older students enroll in college or university systems, for the most part, university level students are at the cusp of transitioning from being youth and minors into being adults. And so in this transitional period, it's considered kind of, the education that concludes the socialization that youth have received in K-12 education. As such, it's not just about exposure to academic material, but to social groups and ideas and skills that may not have been present or as developed earlier in life. And unlike K-12 education today in the United States, under law and policy, there's no basic right to education or to economic access to education. So education at the higher level is not an inherent right that everybody gets to exercise in the way that our policies guarantee for K-12 education. In addition, in K-12 schools in the United States, for some decades now, we've had a body of law embodied first under the Individuals with Disabilities Educational Access Act, or IDEA, and then it became the Individuals with Disabilities Educational Improvement Act, the IDEIA, and we see that these legal mechanisms create ways for students to request accessible education, disability access and education. So not only do you have a right to education at the K-12 level and to have it be free, but you've got some, not the strongest, but still substantial laws guaranteeing right to disability access. The IDEIA, however, stops at 12th grade, right? It stops at high school. And so in higher education, the only rights to have your education be accessible are under laws like the Americans with Disabilities Act or the Rehabilitation Act, which don't provide nearly as much detail about how education should be structured and which are not specific at all to schools. A lot of issues also come up in contemporary higher education. So we know that education opens up economic and social opportunities, that it's vital in completing the educational processes for many from K-12. And we also know that throughout US history, admission to colleges and universities, particularly ones that are higher ranked, but even in general, have been a site of struggle and contestation under anti-discrimination law, whether under the 14th Amendment to the Constitution or beginning in the 1960s under civil rights law, like the Civil Rights Acts of 1964 and 65. So college admissions have been contested around race, around sex and gender, around disability, sometimes about religion or nationality, though those three categories are the most common. And there's also an ongoing dialogue about economic access to education and the way that that affects admissions. But I also want to stress that in the 1950s, the United States started to go through a deeper process around desegregation of education as a consequence of the 1954 Supreme Court decision in Brown versus Board of Education. But we have to keep in mind that the Brown decision was about access to public schools at the K-12 level. So it was not as clearly in its language and discussion about higher education. So the landscape before the Brown decision had been that the US had implemented a requirement of free and accessible public education for minors at large, which by the 20th century included youth of color, but they used the concept of separate but equal, which the Supreme Court had previously enshrined in the Plessy versus Ferguson decision, to justify having different schools for white children and children of color. And we know that the different schools had very large differences in the amounts of resources, funding and staffing and materials that were being invested for white children as compared to children of color. So the Brown Board of Education versus Board of Education decision, in essence, resulted in the Supreme Court saying separate but equal doesn't work. But that didn't apply always as squarely, at least initially, to higher education. Because in higher education, it's not as if students were being segregated into white classrooms and classrooms for students of color. In most instances, people of color, in many instances, women, were just not being admitted or could not be admitted. So the Brown versus Board of Education decision, while it was clear it was going to have a broader impact on civil rights and education, what was not clear is to what extent would it push colleges and universities to make their admissions processes racially equitable. So in the civil rights era, Brown passes in 1954, and it takes another decade until 1965. And Congress passes the Higher Education Act of 1965. They did this on November 8th. And it did a number of things. It wasn't explicitly, in almost any respects, a race-conscious or gender-conscious piece of legislation, which it wasn't, meaning it wasn't framed as higher education law. I'm sorry, anti-discrimination law. It did things like develop scholarships and low-interest loans, fund libraries, and attempt to improve the quality of education. But in tandem with other civil rights laws, which were either being contemplated or passed at the time, like the Civil Rights Act of 1965, it acted to make higher education more economically accessible, as civil rights law acted to make a wide range of institutions, including higher education, less discriminatory based on categories like race or religion or sex. So the continuation of the civil rights era combined with the Higher Education Act of 1965, which was understood as part of the package of civil rights legislation, started to push colleges and universities into the direction of not just being spaces that were set up for the elites. The Higher Education Act led to the development of Pell Grants, which were need-based, and Stafford loans, also need-based. So students could either acquire low-interest loans through the federal government or grants which did not need to be paid back. A little bit later, 7 years down the road, the educational amendments of 1972 were passed, and one of these included what came to be known as Title IX, which prohibits sex discrimination in schools receiving federal money, including but not limited to higher educational institutions. The Title IX was eventually renamed the Patsy T. Mink Equal Opportunity in Education Act. And for those of you who don't know who Patsy Mink was, she was the first woman of color to ever be elected to the US Congress. And she did a number of things in her time in the legislature, one of which was to sponsor and push very hard for the passage of Title IX. So in her honor, after her death, it was named the Patsy T. Mink Equal Opportunity in Education Act, and includes Title IX. So we've got now law to make higher education more accessible as of 1965. We've got the precedent of Brown versus Board Education, which at least, even if it didn't specifically address higher education, indicated that equality in schooling was a goal. And this was backed up later by civil rights legislation like the Civil Rights Act of 1965. And then the Educational Amendments Act comes along and prohibits sex discrimination. So education becomes something which is meant to be more economically and practically accessible and less discriminatory, which is significant not just in terms of the experience of education, but because we know education functions as a gatekeeper or key requirement in economic and professional advancement for most people. So we're seeing all of this playing out in the late 60s and 70s. It took a while longer, but eventually the Americans with Disabilities Act passed in 1990 and did impose some additional requirements on institutions of a wide variety, including educational institutions, which were not already covered under prior civil rights law. And the Individuals with Disabilities in Education Act, right, the original IDEA was also in place, but again, while it perhaps created implications for higher education, it was limited in its scope to K-12. So what we start to see after this period is increasing cost beyond what can be explained by inflation generally of higher education. Education gets somewhat more accessible, somewhat more inclusive. It also gets more costly. And we also start to see that opportunities to gain economic security or advance economically if you don't have a college degree have narrowed since the civil rights era, have narrowed over the past 50 years. So you may have heard before statistics that say that what a person could expect to earn in the dollars at the time in the 1950s and 60s with a high school degree, they now need at least a college degree. And to earn what you used to be able to earn with a college degree, you now need some kind of advanced or professional degree. So how much earning power corresponds to having a college degree has decreased while education has become more expensive. Some social analysts attribute this in significant part to a kind of backlash against the civil rights era. In other words, if higher education is no longer just for the elites, then let's find other ways to keep people out and also to make sure that just having a college degree doesn't automatically gain people access to elite spheres of employment. So the social influence of higher education, while still very significant, changed and the economic barriers to higher education increased. In addition, we started to see litigation not long, right, in this sort of, started to emerge in the 15 years after the passage of the Civil Rights Act of 1965. And one of the most notable early decisions was in 1978. And this was the decision in the University of California Regents versus Bakke. And the 1978 decision in the Bakke case basically found that affirmative action policies, which considered race in establishing quotas for admission, violated the Equal Protection Clause to the Constitution. So it basically said, even if your aim is to achieve racial equity, if you're considering race, then that's discriminatory. And therefore it violates the Equal Protection Clause. This decision did a lot of damage to efforts to develop policies at state or school level to achieve more inclusion. And it also heralded the emergence of what was known as colorblind doctrine in the federal courts and eventually in the state ones. So the idea of color blindness, right, is that if you are acknowledging race in some formal policy, then that's discrimination based on race. And this idea of colorblindness was at odds with many of the ways that people in the civil rights era had been advocating, because, for instance, civil rights, Black Power, Brown Power advocates has not been saying we should ignore race. They had been saying essentially we should remedy histories of racial justice and eliminate discrimination. So colorblind doctrine kind of limited the elimination of discrimination to eliminating recognition of race. And one of the challenges when you do that is it doesn't then, like, so if you say a school can't consider race in its policy, if there are already racial barriers to whatever process the school has, in this case, an admissions process that pre-existed the university, then it can't overcome those. And if there are other barriers in the system, then it can't use quotas to remedy them. So colorblind doctrine basically said you can't overtly discriminate, right? You can't say we refuse to admit people of a particular race or have a policy that overtly says we will exclude them, but you also can't recognize them to try to make sure that you include. The 1978 Bakke decision was followed by Proposition 209, a voter proposition which was put on the ballot in California. And some of you may have heard the saying, it happens in California first, because California is the largest state in the United States and accounts for more than 10% of our population. Often early policy changes will be tested in California before spreading to other states. So Proposition 209 initiated a formal ban in both employment and contracting and in higher education on considering race or gender as factors in admission or participation in any kind of program. So, and in employment, including employment eligibility and retention and hire. So mentoring programs were conceivably called into question. Any sort of program that was geared towards ensuring that businesses or schools did have to include some people of color. Those were all also generally understood as banned by Proposition 209. Interestingly, and not surprisingly, but somewhat insidiously, the advocates for Proposition 209 used a lot of civil rights era imagery and language, including recordings of Dr. Martin Luther King in their commercial advertising for the proposition. So what they announced to the California public is this proposition will ban discrimination based on race and sex. But when you actually read the text of it, it doesn't say, what it actually says is basically we will ban consideration of race and sex, and equates that with discrimination. So once California led the way in 1996, other states started to follow, notably Michigan was looking at this question and became the site for two Supreme Court cases, which were basically accepted for Supreme Court review within a month of one another. Both of them dealt with the University of Michigan school system. One was Gratz versus Bollinger in 2003, which focused on the university's undergraduate admissions policies and their consideration of race, and alleged that these policies, like Bakke, violated the Equal Protection Clause. And the 2003 Supreme Court found for the plaintiff, who was suing the University of Michigan system, and said, indeed, the consideration of race by the University of Michigan in admissions in undergraduate education violates the Equal Protection Clause of the 14th Amendment to the Constitution. This got a majority vote, but there were dissents by several of the justices, and one that was by Justices Souter and Ginsburg, which addressed why the Equal Protection Clause should not ban this kind of consideration. Literally within a month, the Supreme Court also decided Grutter versus Bollinger, also in 2003, also targeting the University of Michigan system. The difference, though, was that it was targeting the School of Law, not the undergraduate program as a whole. And in this case, the University of Michigan won, and Grutter, the plaintiff, lost. And the reason was that the court found that the University of Michigan law school system was doing a complete and individualized review of each student, in which race was not disproportionately considered. So it was part of a much more individualized and whole package. And the university system argued that it had a compelling interest in racial diversity, and that their admissions policy was tailored narrowly enough to only achieve that aim, to just help ensure racial diversity without sort of de facto treating race as a broad umbrella. Now, the court's rationale in Grutter versus Gratz has never been entirely comprehensible, or at least without contention, because the University of Michigan undergraduate policy wasn't treating race as a complete blunt instrument. There were still multiple factors going into admission, but we can at least say that the Supreme Court believed that the law school's process was less broad and was more comprehensive, and therefore was less likely to narrow the equal protection clause. So the Grutz and Gratter decisions basically said there's a little bit of room left for considering categories such as race and gender in university college admissions, but not much. Basically, if you can show you're only doing what you absolutely have to, and no more. And one of our audience members in Zoom is commenting that in the Bakke decision, what it essentially did was ban quotas, but didn't say that no consideration of race was completely disallowed. So it wasn't pure color blindness. And I appreciate that comment, and that's correct. Thank you, Barry. So the Grutter and Gratz decision added to that and basically said, not just relative to quotas, but in general, consideration of race may be disallowed. So I want to talk about that because it really bears on the question of, will the structure and attenuation of higher education change or continue to change in the wake of the civil rights era, or will its status as an elite space be maintained? So continuing questions related to that concern exist now in a few different areas, and I'm only going to just briefly reference seven of them, though there are more that we could easily talk about. So some areas in which policy is at issue around universities and colleges today. And this can be both law, policy created by states, or by the federal government, and also can be about university and college internal policies. So one involves the question of standardized testing and the role it plays in admissions. We now have a pretty substantial empirical literature coming out of the social sciences that basically shows us that there are racial and, in some instances, gender disparities and definitely socioeconomic disparities which affect standardized tests, but if we control for other things, don't necessarily determine what a person is otherwise capable of academically. In other words, we have data that says two things. One, standardized testing is biased. It's not the most equitable way to assess academic possibility. And two, people outperform their test scores all the time. And the likelihood of someone doing that also can correspond to race and socioeconomic status. So it continues to be a contested question. Can the tests be made more equitable? Should they be discarded entirely? Does standardized testing serve a necessary function in admissions? Another major question that affects the character and policy governing academic institutions, which we haven't already talked about, is intellectual property. So though this doesn't on its face immediately bear on the question of whether universities and colleges are elite institutions, it's definitely one of the emergent and ongoing areas in higher education law and policy, and can sometimes bear on the question of elitism or accessibility of higher education in a few indirect ways. So intellectual property basically refers to who owns what students, faculty, or staff in academia create. And this is significant for students too. So some of you at some point in your life, I'm sure, have drunk Gatorade, the drink. Gatorade was invented by a graduate student at the University of Florida. It was named after the school's mascot, the Gators, eventually. And the student was trying to create a drink which would be helpful for athletes or people exercising to replenish their electrolytes and vital nutrients with. And the university took complete ownership of the invention and made quite a bit of profit selling off the rights to Gatorade to the companies that marketed it. And the student received none of that profit. So this is certainly an issue that faculty and graduate students tend to be concerned with. And it also bears on the question of, you know, if you admit people into higher education who were previously excluded, and they make wonderful things or invent things or do things that are unique, who owns that? Who owns that work? Does the previously and still somewhat elite institution own it, or do individuals own it? So some people link intellectual property struggles to questions of educational equity, though I would say it doesn't always have to be as clearly tied as some other areas like standardized testing. And intellectual property law in higher education, again, is an evolving area involving a line of court cases, which in some instances support universities and colleges exerting ownerships over both control and licensing and profits derived from things that people in the institution create. And in other instances, create some limited intellectual property rights which belong to the individuals who create the intellectual property. So the sort of what and when of that is an evolving area. A third major question bearing on educational access and equity and its social function involves cost, which, as noted, has been rising over time and quite dramatically in the past 20 to 30 years. So you can't, if you're engaged with popular media today, miss conversations sometimes happening about student loans and the debt crisis. The fact that people are having to take out deeper and deeper student loans in order to get higher educational degrees, and then are sometimes prevented from achieving economically because they're burdened by that student loan debt relative to their earning potential. And this is a dynamic that's, exacerbated by things like a low federal minimum wage, which is currently under $8 an hour. So, where people, even when people are getting sort of better professional opportunities as a result of higher education, when a living wage in the United States is not that high on average. One of the things we see is a lot of people are struggling to keep up with student loan debt, and this prevents people from, for instance, either pursuing more education or buying a home, both of which increase economic stability if you can do it. In addition, people who default on student loans suffer a lot of damage to their credit, which then again can affect things like home buying, home rentals, other kinds of economic and social opportunities. Fourth major area at stake in contemporary education is sexual assault and gender equity. And this continues to be an area that's litigated. There's now a full scope of legal doctrine that's emerged in the courts growing out of Title IX litigation, thanks again in significant part to Congresswoman Patsy Mink. So litigation that challenges gender equity. Title IX has become a major way of challenging dynamics of sexual assault, which universities fail to either prevent adequately or to respond to adequately. So when there's violence on campus and it's sexual or gendered in nature, Title IX has become the primary basis on which, at least in the federal courts, students or other members of university or college communities can challenge gender inequity. And most major campuses and colleges will have their own Title IX officer, whose primary responsibility is basically taking in complaints related to gender discrimination, sexual harassment, sexual assault, or disparities, for instance, in pay or opportunities. We continue to struggle with the question of race and economic opportunity, and with admissions being a major factor there. So a number of schools continue to exist under outright state affirmative action bans, with affirmative action again referring to policies that create steps that require institutions to remedy racial and gender disparities. We also have some disability-based discrimination law, which functions under the broad frame of affirmative action. So a lot of state bans, and in addition now, because of the Grutter and Gratz decisions, universities and colleges around the country, especially those receiving federal funding, need to be concerned about a constitutional challenge if they try to have overt policies that are about acknowledging race or gender in order to remedy racial or gender inequity. So you can have a non-discrimination office, but you have to be very limited in the ways in which you attempt to remedy discrimination. A sixth way in which university environments and the meaning of higher education, the law about higher education continues to involves universities as employers. In many instances, we see major struggles between labor unions, including those representing blue-collar workers in university and college systems, custodial staff, groundskeepers, security staff, and those representing academic and staff labor directly in the provision of education. So, faculty and grad students, for instance, any student workers can conceivably be unionized. So this, again, is an ongoing struggle with different rules in some instances, some rules that apply across the board under US labor law, some rules that are distinct based on whether you're talking about a private or a public school, with additional provisions if it's a religious school, and others that vary based on what areas of labor law the faculty members or workers are trying to use. So labor rights are significant as well. And one of the reasons this matters to the broader character of the institution beyond integrity and ethics is that discrimination in employment can be a major barrier to kind of equity in higher education at large. In other words, under hiring or under tenuring various groups like people with disabilities in some disciplines like the STEM field, science, technology, engineering, and math, the underrepresentation of women. And so, sort of having equity in who is teaching, who is producing research continues to be an area of struggle, again, mostly emerging in labor law with corresponding overlap in civil rights law. The last major question in higher education is what happens with disability discrimination? So unlike gender and race, disability has generally not been banned either by the courts or by any state or federal law as a basis for affirmative action. So university and colleges are allowed to explicitly consider disability, for instance, in their admissions policies. And we can talk more during Q&A if some of the audience members have questions about why disability is treated differently. But in general, we know that disability and race and gender are treated differently under constitutional law, under the Equal Protection Clause, because courts presume that there is more of a rational basis for treating people with disabilities differently because people with disabilities are physically, in the eyes of the court, or medically different. And there's some basis, right, for treating gender differently because there are some organic biological differences based on sex, like the ability to get pregnant or to breastfeed, though gender, of course, is more complicated than sex, or both are complicated. But race discrimination in particular, under contemporary equal protection doctrine as it's evolved, and under a lot of the interpretations applied to federal civil rights law, is generally treated as suspect if it's acknowledging the social category, in this case, race at all. So basically, where race and disability and race and gender affirmative action saw major crackdowns after the civil rights era, disability affirmative action was allowed to survive. However, it was and is very poorly enforced. So disability-based affirmative action is allowed, but it's often really ignored, in part because there aren't as many strong instruments to enforce it. And so often what happens is, either in admission, if you can prove anything, or after the point of admission, disability discrimination, higher education, mostly, again, emerges under either Title II of the Americans with Disabilities Act, which affects public universities and colleges, or Title III, which governs or determines places, basically businesses that serve the public, which includes private universities and colleges. So the Americans with Disabilities Act is part of how we try to achieve equity for people with disabilities in higher education. We've got a number of efforts to make education more economically accessible and ongoing struggles in the court around affirmative action programs and race-based discrimination. Despite all of the contestation, back and forth struggles, progress, and retrenchment, around equity in higher education, we see that higher education today is still far more equitable in terms of both accessibility and attainment of various groups than it was, let's say, in the 1960s and 50s, or certainly in earlier periods. And corresponding to this change, as education has gotten somewhat more accessible and inclusive, we've simultaneously seen partisan differences in how higher education is viewed and an increasing right-wing backlash against higher education. So just to give you an example, today, 58% of Republicans say colleges and universities are having negative effects on society, whereas in contrast, most Democrats, 70%, say it's having positive effects on society. So 58% negative for Republicans, 70% positive for Democrats. The Tea Party, which, as some of you know, is a right-wing populist organization that claims to be challenging the elite and advancing patriotism, and does so through a lot of racist and anti-immigrant and anti-Obama rhetoric and Trump rhetoric. The Tea Party has become particularly known for seeing higher education as a bastion of the left. In other words, the Tea Party's rhetoric is that universities and colleges have been taken over by radical leftists who indoctrinate students to believe in anti-American ideas. And so you started to see, particularly in the 2000s, this somewhat before, this increasing discourse in the grassroots right wing and in some of the mainstream of the right wing, basically saying higher education is our enemy. And we can understand recent attacks on critical race theory, which is a field that has emerged through US legal education to describe discrimination and racial oppression as it's been built into the US legal system. So the attacks on critical race theory as like a threat to America are part of this longer and an escalation of this longer pattern of colleges and universities coming under right-wing attack, the more they become spaces in which people are able to A, gain access, and D, do racial justice or feminist or economic justice work. So just a couple last things I want to cover in today's episode. One, I just want to mention that there are emergent areas of legislation right now at the state level and also in our current session of the US Congress, which is the 117th session, running, for those of you who are not familiar, from this past January till December of next year. So basically our 2021-2022 Congress has a number of bills under consideration, which if passed would start to shift these dynamics. Again, they're quite a number, so I wouldn't try to review them today, but I'll mention one, which is the College for All Act of 2021. And this has been sponsored in the Senate by Bernie Sanders and in the House by Pramila Jayapal, both very associated with Progressive Caucus in Congress. And if the College for All Act of 2021 were to pass, it would essentially make most public higher education free for everybody. There would be some exceptions for the very rich, but basically poor working class and middle class people could have access to free higher education, and the act goes through how they would proceed to fund that. So it would basically end the need for student loans, because only people who didn't need student loans would have to pay anything for school, and would remove economic barriers for the most part to education. A second piece of legislation that's up now and has been sponsored in past comes from Representative Ayanna Pressley, who is sponsoring the Student Borrower Credit Improvement Act. I believe this one is only in the House right now, meaning it doesn't also as yet have a sponsor in the Senate. What Representative Pressley is advocating for is to basically make it so that if you default or are late on a student loan, you are allowed to get caught up with your payments. So, basically get your loan back out of default status, and then remove any damage from your credit report. So she basically says the inability to keep up with student loans shouldn't cause you long-term damage. It should be something you can have removed as soon as you are getting your loans paid or managed again. So this also would, address one problem, which is the fact that not only is student loan debt so high, but then to be able to cover it, or when people can't cover it, it's damaging their economic opportunities by damaging their credit. I want to close today with a book recommendation from Osagie Obasogie, who is both a legal scholar and a sociologist. And he wrote a book called Blinded by Sight, Seeing Race Through the Eyes of the Blind. And it's an interesting and provocative empirical study, which addresses the idea of color blindness. And what he did was basically go and complete qualitative interviews with people who are blind to ask them to talk about how they perceive race. And his goal here was to sort of expose a mythology in the idea of color blindness, which is if you don't recognize or see race, then you won't be racially discriminatory. He basically said, not only is it impossible to not perceive race in our society where race is so significant, but even blind people can do it. So the term color blindness is problematic in its conception. So for those, again, interested in these major questions about access and the 14th Amendment and affirmative action programs and discrimination, Obasogie's book is an interesting and, again, provocative read. So I want to invite folks to join us next week for our upcoming episode on the 8th Amendment. Our 34th episode is now open for registration. And for our Zoom attendees, you'll receive an information to our link to our event registration page and your follow-up information. For our podcast listeners, you can find a link to our Zoom registration page in the podcast description if you ever want to sit in live. So again, we'll be back on October 17th with the 8th Amendment, and then on October 24th, we'll be devoting episode 35 to same-sex marriage. So the 8th Amendment on the 17th, same-sex marriage on the 24th. Please continue to tune in. We really, really appreciate your presence, and Zoom audience, if you would like, hang out for a minute and we'll be glad to take any, and I'll be glad to take any questions and hear your thoughts. Thank you, everybody.